All right, welcome everybody to this month's Return to the Vault program, navigating the NAR, or their National Association of Realtors proposed settlement and what lawyers need to know. As always, my name is Matt Waters. I'm an attorney at Jordan Price Law Firm in Raleigh, the immediate past chair of the real property section and co-chair of the Return to the Vault program. Glad to be joined today by Bob Ramser with Ragsdale Liggett, co-chair of the Joint Forms Committee, and also Charlie Moody, Deputy Legal Counsel for the North Carolina Real Estate Commission and the Real Estate Commission liaison with our council. And as always, joined today by Kyle Smalling with Capital City Law here in Raleigh, co-chair of the Return to the Vault program. Glad to have everybody with us. So a little bit about the Return to the Vault program. If you're new to this program, this is a program we created in 2022 as a way to sort of bridge the gap and reconnect all of our members, and it's been real successful in doing that across the state. It's been a way for us all to re-engage and re-energize ourselves. These are monthly 1-hour programs recorded on the second Wednesday of each month at noon. They're saved as content for our section. You can find them on our section website, where you can find all presentations, slide materials, and so forth. These are not offered for CLE credit, but we're glad to be able to present this useful and helpful information to you on a monthly basis. Quick announcement, upcoming programs, September 20th, make sure you're registered for the Real Property Advanced Topic CLE. Then in February of next year, the Real Property Hot Topic CLE, which is also in its planning stages. And then in May of next year, our annual meeting in Kiawah. Hope to see you all there. One thing I don't have on this list, but keep in mind it's upcoming again, which is our very popular Carolina Hurricanes tailgate. That'll be early next year, so be on the lookout for some notification from the real property section as to how and when to register for the drawing. We've got our largest block of tickets that we've ever had for that, and it's going to be a great game and a lot of fun. All right, I want to welcome again Bob Ramser and Charlie Moody. They have been very gracious to join us today and give us a lot of information about this NAR proposed settlement, which many of these rules, and I don't want to take or steal too much of their thunder, but I know that the rules that went into effect in August were the largest changes in how realtors operate their business in decades. Bob Ramser, his practice is focused exclusively on residential and commercial real estate transactions, lease drafting and negotiation, construction and development, tax and entity structuring, real estate litigation, and the representation of professionals in ethics and disciplinary matters before occupational licensing boards. He is a member and past president of Relink. He serves on, again, as the section counsel for the North Carolina Bar Association Real Property Section and chairs the Joint Real Estate Forms Task Force of the North Carolina Bar Association and NC Realtors. He is a member of the Wake County Bar Association, 10th Judicial District Bar, and the Wake County Real Property Lawyers Association. In 2023, Bob was appointed to serve a 3-year term as a commission member for the North Carolina Real Estate Commission, and he's a great colleague and friend of mine, and been glad to work with him on the council. Charlie Moody is Deputy Legal Counsel and Assistant Director of the Regulatory Affairs Division with the North Carolina Real Estate Commission. She's a native of New York. She attended Duke University and received a degree in public policy. She then attended UNC Chapel Hill School of Law, receiving her JD in 1998. Following graduation from law school, Charlie entered private practice in Atlanta, where she specialized in general business litigation. She then joined the Real Estate Commission in February 2006, where she's been since. Charlie's duties at the commission include prosecution and settlement of disciplinary cases, participation in the NC Association of Realtors and the North Carolina Bar Association Forms Committees, and oversight of the timeshare registration program. And Charlie is a great resource. She's been a great resource and colleague of mine, and I'm sure many of you, and someone that is always willing to pick up a phone or respond to an email anytime you have a question. And like I said, very glad to have both of them with us today. So with all of that, I'll turn things over to Bob and to Charlie to talk about NAR.
Great. Thanks, Matt. I appreciate the opportunity to speak to everyone, and welcome to the members of the section who are, I'm sure, getting bombarded with questions about the NAR settlement. Charlie and I hopefully can walk you through it a little bit and give you some insight that might help your practice, helping your real estate broker clients. First, a little bit of background about the settlement. There was a class action lawsuit filed, the Burnett Sitzer matter versus the National Association of Realtors, that was basically an antitrust lawsuit that was certified as a class action. The case arose out of Missouri, and the NAR folks fought it and went to trial and lost. And there was a $1.8 billion judgment that was entered against the National Association of Realtors. And of course, that's not a number that they could pay, nor post an appeal bond. So they were really kind of forced into settling this litigation with the plaintiffs' lawyers. So on March 15th of 2024, the NAR, National Association of Realtors, proposed a settlement to end this lawsuit. The lawsuit, in addition to NAR, it also included a lot of state and local realtor associations and association-owned MLS entities. For example, while not a named plaintiff, our local MLS entity is the TMLS, the Triangle Multiple Listing Service. I believe in Charlotte, it's the Canopy Multiple Listing Service. But this Missouri MLS was included in this litigation. So in the settlement proposal, NAR agreed to pay $400 million of the $1.8 billion judgment that would be paid over 4 years. And in addition to the damages, the plaintiffs' class wanted them to mandate that the members of the NAR have to enter into written broker agreements with buyers. Now, in North Carolina, this was not a monumental shift because we've had buyer agency for as long as I've been practicing law. But in a lot of states, the concept of buyer agency was just a foreign concept. So the proposal does require now that a buyer enter into a broker agreement with an agent. Additionally, the settlement prohibits realtors, and this is probably the most significant aspect of the settlement, is that realtors are no longer allowed to advertise cooperating compensation on the multiple listing service. So if you've got any familiarity with MLS, you list 123 Main Street on behalf of your client. You put in the comments for the agent remarks, we are willing to pay a 2.4 commission to any agent who brings forth a buyer. Those are now under the settlement prohibited. The settlement still needs to be final. They need to get final approval, which I believe is in November. But the settlement did receive preliminary approval, and the NAR went ahead based on that preliminary approval and made the changes well, they were required to by August 17th. I believe that our local association changed them on August 1st, if I'm not mistaken. So with that background, one of the biggest misnomers that I'd like to briefly go over with you, just so that you can get this in the context of where it may be coming from, is that the North Carolina Real Estate Commission, of which I serve as a commission member and Charlie serves as a member of our staff, we are completely separate from NAR and from North Carolina Realtors. So if you can imagine, this is very similar to the North Carolina State Bar and the North Carolina Bar Association, two completely distinct entities. The Real Estate Commission's primary function, similar to the bar's function, is to license and regulate real estate brokers and to protect consumers. The trade associations, such as North Carolina Realtors, National Association of Realtors, and local associations, their purpose is more to support the members of the association, the trade association. So North Carolina has about 100,000 plus licensed real estate brokers. Many of them are also members of NAR, but not all of them. Okay, so the term realtor gets thrown around fairly loosely, but not all real estate brokers are realtors. And certainly not all, but all realtors are real estate brokers, if that makes sense. So with this NAR settlement, the first thing to really kind of plug into is the NAR settlement did not change a single aspect of the North Carolina Real Estate Commission rules that are currently in place. So the rules apply only to members of the National Association of Realtors. So out of our 100,000 plus brokers, not all of them have to or are required to follow the terms of this settlement. So realtor members can comply with these NAR changes, and they're not violating the license law and rules in doing so. And there's a little bit of overlap, which Charlie and I will get into in a minute. We'll try to help you navigate that for your clients. But I'd like to turn it over to Charlie right now, who's going to go over some of the important real estate commission rules that we have on the books.
Good afternoon, everyone. Happy to be here. So right now I'm just going to talk about two of the most important rules that apply regarding agency agreements and agency in this state. The first one is our working with real estate agents disclosure rule, which is Commission Rule 0104C. And this is the requirement that brokers in any sales transaction must provide every buyer and seller with our working with real estate agents disclosure at first substantial contact. And that helps describe for the consumer the broker's possible role in the transaction, whether it be as a buyer agent, as a listing agent, as a seller sub-agent, if the buyer does not want any representation, or as in a dual agency role where they represent both the listing and the buying side. In North Carolina, a broker cannot be a non-agent. They have to represent either the seller or the buyer or both as an agent with those fiduciary duties. And this form is required to make the appropriate disclosure and have consumers understand what is available to them when they are using a broker. This is also the time when it's perfect for the broker to start having that discussion about compensation.
I mean, they shouldn't get it mixed up, but put
Sorry, I think I hear someone, but so that's a requirement that has not changed. And one of the important questions is first substantial contact. First substantial contact, ideally, when you first start talking to someone, but no later than that time when the broker is about to discuss confidential information, such as a seller's need to sell, how much they need, how much their mortgage is, or for a buyer, how much they can afford, etc. So that's working with real estate agents disclosure, Rule 104C, and again, no change. Similarly, in North Carolina, under Rule 104A, a broker has to enter into written agency agreements with their buyer and seller clients. The timing of that is different depending on the side the broker is on. For a listing agreement, it has to be in writing and signed by the broker and client at the time their agency relationship is formed, right away. So before they start any services for that seller, they need to have a signed listing agreement. For buyer agency agreements in North Carolina, again, they must be in writing and signed by the broker and client. But at this point, it's no later than the time they're making the offer. So if that broker is filling out the offer for the client, they should also be entering into a written buyer agency agreement. Before they're at that step, under North Carolina law, the buyer agency agreement can be oral. They can have the discussion and come to agreement, but nothing has to be in writing until the time they're ready to submit an offer. If the buyer doesn't agree to buyer agency oral or written, then the broker working with that buyer must have an agreement, not necessarily written, but an agreement of sub-agency from the seller or listing agent. And then they're working on the seller's behalf, not the buyer's behalf. And that really should be understood early on because, of course, as we know, as an agent, we have fiduciary duties to our client. And if you're working for the buyer, those duties are going to be for the buyer and you're looking out for their interest. If you're working as a seller agent or seller sub-agent, your duties are to the seller. Now, as to the NAR settlement, the rule in North Carolina doesn't prohibit a broker from entering into a written buyer agency agreement earlier than the time of offer submission. So where the settlement requires a written agreement earlier than in North Carolina, a realtor can still sign the written agency agreement earlier, and it doesn't conflict with the commission's rule. There's no requirement that a buyer agency agreement is signed as late as submission of an offer. And as a reminder for all brokers, we do have to remind people there is no allowance for non-agency brokerage in North Carolina. They can be a buyer or seller agent, dual agent, or designated dual agent. Finally, Rule 104 also has some specific requirements for any agreement for brokerage services. And that would be a definite termination date, specific fair housing language, and that includes a broker's license number. So if anyone is drafting any sort of new agreements, touring agreements, showing agreements, however they might be termed, they always have to include those three things: termination date, fair housing language, as is exactly written in the rule, and the broker's license number. So now we're talking about agreements. I'm going to turn it back over to Bob so he can talk more of that.
Yeah, so part of the confusion between what's going on in the marketplace right now is this kind of intersection between NAR and the NC Rec rules, which Charlie just talked about. But I'd like to get into the NAR agreements because they are separate and distinct from what the commission requires. So under the NAR settlement, an MLS participant, that's how it's defined in the settlement, but we can say a realtor. If a realtor is going to work with a buyer, they are required to enter into a written agreement with that buyer before they can show that buyer a house. So if I'm a buyer's agent, my phone rings, someone calls and says, I would love to see 123 Main Street. I can't walk into that house with that buyer until I have a written agreement with that buyer. Touring a home also includes walking through the home, even if the person is not there, meaning I can't walk through a house and do FaceTime and show someone the house unless I have a written agreement. It does not include, however, videos that are posted by a listing broker to advertise the property. So for example, if somebody posts a video that's a listing agent, there's no requirement that an agent go under an agreement. So this is specifically agreements between a buyer's agent and a buyer. The settlement language does require that it's anyone working with a buyer. So listing agents are not included in this settlement. The settlement language does not require agency, as Charlie just alluded to. It just has to be a written agreement. The written agreement by the rule has to include four things. One is a conspicuous statement of the compensation that the broker is expecting. There are a couple of other ones that it has to be a clear, conspicuous statement that the commissions are not set by law or not mandated by law, but are freely negotiable. And so the realtor who shows a buyer a house does not have to have an agency agreement, just a written agreement. And where the confusion sets in is the Real Estate Commission, of course, requires an agency agreement to be written by the time an offer is made. With the NAR settlement, they require an agreement at the time a house is shown. So in the void between the time a buyer first looks at a house and the time that they want to make an offer, they can exist under an oral agency agreement with the broker. Okay, so if I want to show a house to a buyer and the buyer's not willing to sign an exclusive agency agreement with me yet, we can go under an oral agreement for agency, but a written agreement as to the compensation that satisfies the NAR requirements. So that is kind of where it is. The North Carolina rules, of course, as Charlie mentioned, do require a definite termination date, fair housing language, and the broker's license number. So if you're being asked to prepare any type of a touring agreement, make sure that you address those as well into that agreement so that you're not only in compliance with the NAR settlement, but you're in compliance with the NC Rec rules. Charlie's going to go back and talk about other agreements between the buyer and the broker.
So just as there are joint contract forms drafted by NC Realtors and the North Carolina Bar Association, NC Realtors has formed agency agreements for use by its members. That's not a jointly approved form. Those aren't jointly approved forms. That's just the Realtors Forms Committee, and I actually serve on the residential and commercial forms committees, so I'm pretty familiar with all of these agreements. So there is normally the exclusive buyer agency agreement that is at a minimum signed by the time of making of an offer. Now, buyer brokers can require buyers to sign a buyer agency agreement prior to touring any homes so that the broker complies with the settlement and they've complied with North Carolina Real Estate Commission rules. They can do that. However, some brokers are concerned that a buyer might not be ready to sign a full exclusive buyer agency agreement at that point in time. So there are other options. Currently, there exists a non-exclusive buyer agency agreement that can be signed that basically says we're in agreement that I may at some point become your exclusive buyer agent, but you are free to work with other buyer agents at this time or at any time, but we have a written agreement. And that would comply with both, again, North Carolina Real Estate Commission rules and the settlement and the NC Realtor rules at this point. There are also touring agreements that I know some individual firms, some individual brokerages, and I think some national companies have drafted. That would permit a broker to show a home to a buyer with limited contractual obligations on the part of the buyer. Some of these might have a small fee or no fee at all, and they might be of limited duration or property. So you could do 1 day, 1 week, 1 property, 1 subdivision, etc. But again, I'm just going to keep saying it. Any touring agreement, other agreement, non-exclusive agreement designed to meet the NAR settlement must comply with our commission rule AO104, writing, termination date, fair housing language, and the broker's license number. I will say that NC Realtors in July revised all of their agency agreements to comply with the settlement, but they are continuing to look at their agency agreements to make them better and see if they can make more people happy. And they're also looking at a possible touring agreement, and they've also done, other agreements to try to facilitate this change. But that's our advice is, you have to have some agreement, but if you're asked to draft one, you might want to take a look at other forms, but make sure they comply with commission rules. Bob?
Oh, I'm sorry, Charlie. Didn't mean to cut you off.
No worries. Turning it back to you.
Okay, yeah, compensation is the question that most practicing lawyers are going to get a lot of phone calls about from their broker clients. And so I want to spend a little bit of time talking about how compensation works. The first and most important thing that every lawyer needs to know is that the North Carolina Real Estate Commission has Rule 58A.0112, which specifically states that real estate brokers cannot use a pre-printed offer or sales contract form that contains any provision concerning the payment of a commission or compensation to a broker or firm. That includes attaching any type of an addendum to the contract, making the offer contingent upon a seller agreeing to pay a buyer's agent's commission. And this is the big thing. The rule says, even if it is drafted by the seller or an attorney. So if you are asked to draft anything that addresses compensation as part of the offer that is being made, do not do it, because you are putting your client in jeopardy, or the broker in jeopardy of violating real estate commission rule. Now, a client can consider the amount of the commission when they're making an offer, but the firm should not ever be made a third party in any form contract between the buyer and the seller. And it's my personal opinion that a contract is between a buyer and seller, and that brokers need to kind of deal with that separately off the four corners of a contract page. It is prohibited by rule to be on a pre-printed form. It probably should not be done on a non-pre-printed form, although I would assume that a buyer could ask a lawyer to draft something that would satisfy the rule. It's my experience that no buyer is sophisticated enough to know that they should do that or have the ability to do that. It's more than likely going to be driven by a real estate broker, which is prohibited. So don't get caught doing that. The current standard form residential contract, which you're all familiar with, does include a provision that allows the seller to pay an agreed upon amount towards any of the buyer's expenses. And if the lender for the buyer would allow that, that is a one way around the rule 112, which is you could put the amount of compensation being offered a buyer's broker as a expense in that blank. But again, you need to check with the lender for the buyer to make sure that that amount of concessions is not limited in any way by the terms of their loan. With regard to compensation for listing agents, if you are a listing broker, it's important that the listing agent discusses those offers of compensation with the seller up front. There's pros and cons to any offer of compensation. Now, what's a little bit unusual, which is happening in the market now, is that we've introduced Realtors Form 220, which is called a cooperating compensation agreement. That form specifies who is going to pay any compensation that's being offered to a cooperating buyer broker. And where it's a little bit confusing is because there are two options. The listing firm can agree to pay a cooperating broker compensation out of their commission or their fee, but a seller can also agree to make an offer of compensation. And what we're seeing in the market when everybody's trying to navigate these changes is there's a large firm in North Carolina that has decided that the firm will never pay compensation to a buyer's broker, and they're going to require that the seller pay in 100% of their listings. There is another firm in North Carolina, almost as large as the first, that have the exact opposite read on it, and they are going to pay a fee to a cooperating broker in 100% of their cases and not require the seller do it. No matter which method you suggest or that is done, it's important that the seller and the listing agent have this discussion to be prepared to list a property for market, because that is going to be a very important item of interest for any buyer or buyer agent. So if a seller does agree to compensate a buyer's agent, they can sign that Form 220 and they can have it ready for a prospective buyer's agent. There is a local firm in town that has a link to their website on the MLS listing. If you make a couple of clicks, you can find the Form 220, which is already listed on their home website, and enter into an agreement to get paid if you're a buyer's agent. The seller can also delay agreeing to any offer of compensation until a later date, or do so on a case-by-case basis. So, for example, if you have a seller that's not sure if they want to offer compensation to a buyer's agent yet, they don't have to do it up front. They can wait and see what happens. Of course, a lot of listing agents are going to advise them on the con of doing that, which is you may limit the amount of showings, as no buyer's agent is particularly interested in showing a home that they're not going to get paid for, and buyers also aren't going to be too wild about having to pay their own broker compensation out of their own pocket. So Charlie, you go ahead and continue with the compensation for buyer agents and the use of seller sub-agency.
Sure. And I would just add here that part of the panic is that brokers like that there was one way of doing things and it was easy. And it was on, compensation was offered on MLS. There didn't have to be any communication. It was done. Now there has to be a lot more communication. First off, with the buyer agent and the client or would-be client at first substantial contact, when you're using the working with real estate agents disclosure to discuss your agency relationship and what that will be. If that buyer will want a buyer agent or will want a seller subagent, then again, if they are not going to agree to be a buyer client, then they can only work with the client as a seller subagent. So then they're going to have to communicate with the listing side. If they are agreeing to work with the broker as a buyer agent, then that buyer agent needs to make sure that they are discussing the full amount of their fee, including who will pay it. Whether it's going to be that they can seek compensation from the seller or the listing agent, whether there will be an out-of-pocket payment from the buyer for all of that compensation or a portion of the fee. So, I mean, this is a communication that needs to be had before showings. They need to explain to their client that if they choose an offer that has a home that has an offer of compensation and that offer is less than the fee, then they're going to be responsible to pay the difference. So maybe they don't want to see that home in the first place. Again, and if there's no offer of compensation, maybe they do want to see the home. Maybe they are walking in prepared to pay that compensation, but that's a discussion, communication to be had up front. And then the buyer's agent has to determine whether there are offers of compensation on properties that the buyer is interested in. This isn't going to be on MLS anymore, so they will have to figure out whether the listing broker, as some have done, are putting that on their private websites so that they can see a 220 or just a list of what might be offered for certain properties, or whether they have to email or call a listing broker to determine what's the compensation and how does that affect their buyer client, and communicate with their buyer client to determine whether they want to see the property. As for seller subagency, again, it's going to be communication with the listing broker to determine whether there is going to be any offer of seller subagency and whether they can even continue to show that property, or whether they have to back out or say, this is a property that does not offer seller subagency and you are not wanting me to work as your buyer agent, so therefore I can't show you this property. You'll need to go elsewhere. But that's the discussion that needs to be had. So that, again, it used to be just on one site, you could find it. Now there's going to be more discussions among buyer's agents and their clients, and buyer's agents or seller subagents and listing brokers. Bob?
All right, so when Charlie and I were preparing for today, we thought that it might be helpful to do kind of a Q&A about these compensation offers, because you're going to get a lot of questions about it from your broker clients. And so we've come up with some questions and some answers, and I'll also try to answer a few that have been popping up on the messages. The first question is, are compensation offers eliminated? And the answer to that question is no, they're not. They're just prohibited from being offered on the MLS. Okay, they can still be offered by either the listing firm or the broker who's the listing broker, or by the seller. A common method might be to make that offer on a firm's website. We're seeing a lot of that pop up where these offers of compensation are advertised. They just cannot go onto the MLS. There's a multitude of reasons why, but the primary reason is the MLSs were also in large part owned by the National Association of Realtors or by state associations. And so that was part of the antitrust aspect of this entire case. Second question, can a broker attach a contingency to the standard offer to purchase and contract, making the offer contingent upon a seller agreeing to compensate a buyer's agent? And as I explained before, the answer to this question is no. Commission Rule 0.112 makes an absolute prohibition of this. Any offer to compensate a buyer broker is between the listing firm and the seller, and the buyer broker should not be a part of the contract between the buyer and the seller. Okay. Can a buyer ask for seller concessions in their offer and use those concessions to pay for their buyer broker? Now, the answer to this question is yes, they can. However, the seller concessions can be used for whatever purpose the buyer chooses. There's no guarantee that they'll be used to pay for the buyer broker. Okay, so if you've agreed to a seller concession, there's no direction that this get paid directly to the buyer's broker. If a buyer broker uses Form 220, can it be sent to the listing broker simultaneously with the offer to purchase? And the answer to this question we came up with is yes, but probably as a last resort. The buyer broker has to make absolutely clear that the offer being submitted is not contingent upon the signing of that Form 220. The buyer must also understand that the seller might sign the offer, creating a binding contract, but not sign the Form 220, agreeing to pay those the buyer broker compensation. Or they may sign the 220 agreeing to only part of the compensation, leaving the buyer responsible for the rest. So Charlie and I would advise you to advise your clients that if the Form 220 is going to be used, that it be submitted either prior to an offer or at the same time an offer is submitted. But if you're going to submit it simultaneously with an offer, it needs to be redacted and unsigned. So it's technically not even an offer. It's just here are the terms that my buyer client would be agreeable upon paying, because you have to steer clear of the law, make sure you don't make an offer contingent upon the agreement to accept compensation. Can the buyer broker send Form 220 and an unsigned offer to purchase and wait for the seller to sign both before the buyer signs either? And again, just explain yes, the answer is the answer. That may mean that the seller has to initiate more and of the offer and acceptance process. It may prolong negotiations, but it can be done. And again, Charlie and I believe the best practice is for a buyer broker to determine what property suits their buyer client's needs, what compensation is being offered, and then present those properties and the offers of compensation to the buyer and allow the buyer to determine which property they may want to view or consider based upon their own personal financial situation. Okay, so for example, if you have property A, B, and C, and the offers of compensation are different, you can say, well, buyer with property A, they're willing to pay a fee that covers my costs. In B, they're only willing to pay a portion of it. And C, they're not willing to pay any of it. So the buyer may want to take that information and use it to determine whether or not he even wants to make an offer on C, or whether he wants to reduce perhaps the purchase price he's willing to pay, knowing that he may ultimately end up having to pay the buyer broker commission or compensation. Next question, if I'm a listing broker, is it better for my seller to not agree to offer compensation up front and wait to see what the offer is before agreeing to pay a buyer's broker fee, or to go ahead and offer it up front? Either one of those is an option. In both cases, the seller just needs to consider the bottom line in the context of the negotiation process. And again, that's going to be some advice that they're going to have to really get from their listing agent about the marketability of their home when compensation has not been offered. It certainly may affect the traffic of who's going to come by to see your home. Next, if I'm a listing broker and my seller signs a 220 before receiving any offers, does that mean they have to accept the first offer that comes along, or will they still owe the buyer broker compensation? And the answer to that is certainly not. Charlie and I spoke yesterday and we joked about seller could put a 220 on the internet and have every citizen of Raleigh, North Carolina sign it. And it's not binding because the entitlement to compensation is only determined in being the successful buyer of the property, and there can only be one. So compensation is not earned until you're the procuring cause of the sale to the property. And so you can easily put up that Form 220 on a website and have and invite buyer brokers to download it and sign it to get the satisfaction and confidence to know that they are going to be compensated, and more importantly, that they're in a contract to be paid by that broker or by that seller. Charlie, do you want to go over some of these questions that have been put on the chat, or do you want to go to hit the disputes?
Well, why don't we go over the questions in the chat? I think I saw one. Let's see. Can a seller mandate that the listing broker share compensation as part of its listing agreement? And I would say, well, yes and no. The seller can, and again, this communication should be had at the time of entering into the listing agreement, and the listing agreement has been updated to note that there's a section where the seller is agreeing to pay or is agreeing to allow the listing firm to share compensation. So that discussion should be had at the point they're filling out the listing agreement. And the listing agreement includes that, you know, all fees, compensation is negotiable. A negotiation does include saying no. So the seller could certainly say, I'm only signing this if you agree to share compensation. But the listing broker can say no. I doubt that will happen, since that's been the norm for years, that the listing broker shares compensation. But I'm sure that if given a certain percentage, of listing broker might say no, and that you're free to find another listing broker. But yeah, that's in the listing agreement as revised.
Yeah, Charlie, before Lindsay's question, Chris Vaughn had asked a question about Form 220, and he noted that the Form 220 can be shared on an agent's personal website and broker website. But he asked, can the agent subscribe to a platform that allows them to add their listings and to share them, so long as they're accessible through a widget on their personal website? So I think that's a two-part answer. The first is NAR has developed what's called a two-click rule. So if you're advertising on the MLS, you can put in the agent remarks section a hot link to your firm's website or to your brokerage web page. That link click is click one. If it takes you to another page that's on your website and gives you the opportunity to enter in an MLS number or to put in an address and click again, then after those two clicks, Form 220 can be accessible and stay within the bounds of the NAR settlement. So we're seeing a lot of firms that are creatively doing that. It's not really an end around of the settlement. It's just specifically designed to provide information for brokers who are looking for offers of compensation. Then the other part to his question, which I believe I understand, is whether or not there can be a platform that's created that's different, separate and apart from MLS, where the system can continue as it always has. And I don't believe that there's a prohibition against that, because a separate platform would not be associated with NAR. But again, I think Charlie and I would both probably say you may want to think twice about antitrust considerations if that's going to be done, because NAR thought there was nothing wrong with MLS platform before, and it turned out to be a $1.8 billion headache. So I think that's hopefully answers Chris's question.
I agree with you, Bob. I have some concerns about having you know, a semi MLS, if you will. It's not an official, but yeah, I'd be concerned that DOJ might still find that problematic. but I mean, it certainly can't say no to it. I was going to talk about disputes over commissions.
Hey, Charlie, we got one more question, which I
Okay.
think is a great one, because I get this a lot.
Okay.
And I'm sure you do, probably more than I do, but Jennifer Scott asked she asked what the enforcement mechanism is for the settlement. And she asked if the NC Rec rules are followed, who's going to go after non-compliant realtors? So that's a really great question. And I'm sure, Charlie, you're going to get a lot of complaints about violations of the NAR settlement, which you don't have any jurisdiction or care about because you're only in it for the NC Rec rules. And of course, Charlie, you would be the one enforcing violations of any NC Rec rules, but it's my understanding that the local MLSs are charged and the local associations are the ones that are charged with the enforcement of the NAR settlement rules. So if there is a violation of the NAR settlement rules, the the realtor members are subject to discipline by the trade association. And I know I went to a seminar in Indiana about this a few weeks ago, and some of the states were talking about some of the fines that they were implementing, and they were thousands of dollars for violations of the NAR settlement. So you certainly would want a broker to pay careful attention and not get too cute with trying to sidestep these settlement provisions, because there are some massive fines that await those that screw it up.
Right, right. These rules are MLS rules now. So violating MLS rules will subject you to fines and more. So that's not great. So I was going to talk about disputes over commissions. The commission, and I'm so happy to say this, does not have jurisdiction over the setting of commissions or the advertising of commissions or commission disputes between brokers. So, so we're out of that, yay. And we also remind folks that brokerage commissions have always been a negotiable term between the brokers, the firms, and the client, and between the brokers and the firm. So that has not changed. It's been added, that reminder has been added to all of NC Realtors agency agreements. And it might be that some of those negotiations, as I said before, mean that a broker declines to work with a certain buyer or a certain seller. So be it. You've negotiated, you've had those discussions. So what our general advice to brokers and brokers in charge would be are: one, communication has always been essential. Every presentation, every speech I give is about communication. In this post-settlement world, it's imperative. There's no assuming anymore. There is going to have to be more discussion by brokers with their clients and by brokers with other brokers in transactions. And better to have it earlier rather than later, or having disputes come right at closing, or complaints to the commission after closing, because we'll still get the complaints. Even though we say we don't have jurisdiction, we'll still get the complaints. Brokers in charge should create written policies and trainings for their affiliated brokers on how to manage this new world. And it does take some thought, some planning, maybe some consultation with their attorneys. Because the affiliated brokers will have to be trained on how to navigate working with sellers, buyers, and other brokers. And brokers in charge and firms are just they need to stay informed. And as developments occur, things may change. I think the world may change a bit. Bob and I discussed that there might be more buyer agency agreements with determined services that a broker would provide for a certain cost, showing agent versus I'm filling out a contract for you, in order to enable buyers who might not be able to afford thousands to afford at least some representation or some assistance. But we're going to keep our eyes open and hopefully this too will pass. Bob, do you have anything to add?
Yeah, I know we're about out of time, but I wanted to give you a couple of resources in case you have questions going forward. Obviously, Charlie won't brag on herself, so I'll do it for her. But Charlie is a member of the Regulatory Affairs Division at the Real Estate Commission. She, along with a team of really great lawyers, just can answer any question that you throw at them as it relates to Real Estate Commission rules. They are just invaluable resources. I bug the crap out of them constantly because in my practice, when a question comes up, I think I know the answer, but I feel a whole lot better if I run it by Charlie or Janet or one of the other lawyers first. Secondly, John Waite with the Martin and Gifford firm in Winston-Salem is one of the attorneys that represents North Carolina Realtors. He is an excellent resource, as is Bill Gifford. So if you have any question about the NAR settlement and how to comply with that, John is a great resource for you to reach out to. I'm sure he would be happy to take any of your questions. And of course, I, to the extent that I can, would be happy to answer questions. I don't know a lot, but I'm glad to offer assistance if I can. So. Charlie, got Fred, your former colleague, Fred Marino, just popped in with a question. You want to take that one?
I noticed that one. So Fred asks, he's heard that some MLSs may be talking about a requirement that each individual agent have a written agreement with a buyer. Couldn't any affiliated agent with a firm operate under one written agency agreement with a buyer, regardless of who signs it? Well, that would be our view. If a broker meets with a buyer and has, but again, that would depend also on what the agency agreement says. So if this is about a touring agreement or a property showing agreement, I think it would be imperative to make sure that that's clear that this would apply to any agents in that firm, because we always say that the agency agreement is with the firm, but that is in the agency agreement. So it'd be important to make sure that that's what any other agreement says as well.
Yeah, and I agree with you, Charlie. I think the point is follow the compensation, and in almost every case, I mean, the reason for the written agreement to satisfy the NAR settlement is to address compensation, and the compensation is almost always paid to the firm and not the individual agent. So I would believe that as long as compensation with the firm is addressed, it can be uniform no matter who operates under that firm. So I agree with you.
Lindsay asks, would it be a good idea to update the forms contracts with a note that says commission split cannot be added to this contract? Bob, you're the chair of the Joint Forms Committee. What do you say?
I think it would be a great idea, but I'm not sure if I would get support from the realtors on that. And keep in mind that the form contract is a jointly approved form. NC Realtors and the North Carolina Bar Association jointly agree on the changes. The reason I say that is I have a feeling that North Carolina Realtors may want to advocate for a change to the rule of that 112 rule that prohibits that. I have a feeling that they may want to, as the Real Estate Commission goes through their rulemaking process, which we have coming up here in the next couple of months, my hunch is that they're going to want to try to eliminate that rule or at least modify it to allow us to do that. So, Lindsay, I think personally it would be a great idea, but I'm not convinced that it would have any way of getting on the form.
And Bob, I think that's a good segue for something I was going to throw you a curveball, and if you would, or if you're able to give an update to the attendees here about the Word versions of the real estate forms not being available to the membership, and if there are any updates on that issue.
Yeah, no updates from NC Realtors. I have been talking with John Waite, and he promised to get back to me because he wants to get it resolved. Sherrard has gone ahead and they're already undertaking a conversion process to get the PDFs into Word. And just so every section member knows, we recognize that the Forms Library has some work to do. Sherrard is working on it. We're going to get that up as soon as we can to make sure that the members have access to Word versions. The trick, of course, Matt, is that these are copyrighted forms, and the realtors have anxiety about the form being altered by lawyer members who have access to Word versions. And I tried to explain that lawyers don't do that. We just draft addenda to contracts, and we like to copy language and cut and paste it, not reform the four corners of the contract. So that's the latest update. A couple of other questions, Matt, if we've got time. I know we're up
Yeah,
against the clock.
absolutely.
See, I saw one from
There's one from Chad
Jennifer
Tillman.
about Zillow. Zillow has produced a form touring agreement. The form, and Charlie, slap my hand if I'm not saying this exactly correctly, but Zillow has run their form by NCREC for the sole purpose of having NCREC verify that that touring agreement complies with all of the NCREC rules. I'm not aware if Zillow has run that by MLSs to see if it complies with the NAR settlement. Charlie, is that fair?
I agree with that. Yes.
Okay. So I don't know. I haven't seen the Zillow touring agreement form. I prepared my own and ran it by the Real Estate Commission just to make sure it complied with Real Estate Commission rules. But there is one out there, and there are a lot of forms out there. But again, to Jennifer's point, you have to include those three things that the Real Estate Commission requires: the definite termination date, the fair housing statement, and Charlie, the third one, which my mind
License number.
and the license number, yeah. And then it also has to comply with the 4 requirements of the NAR settlement rules.
Chad has asked, and I know we've gone over this and discussed this amongst ourselves, that, you know, some attorneys would believe that an attorney drafted addendum was not contained in the pre-printed form. But my opinion remains that an addendum is stated as being attached to and part of this form is the same as contained in. It's no different from writing it in a blank. So, but again, 112 will probably be looked at this rule cycle.
Yeah, Charlie, correct me if I'm wrong. It isn't 112C. I don't have it in front of me, but I think 112C might give Chad a little bit even more direction on that.
Yes, C is the.
C is the kind of the catch-all provision, I think, that provides it. But to answer his questions, certainly you could litigate it, but I think you would want to litigate it in a deck action rather than in the context of a commission complaint defense.
Bob, and Charlie, there's one more question here in the chat box, and I'll read that for everybody. Provided that a buyer's agent receives written consent from a buyer to disclose a buyer's agency agreement to a seller, and the buyer's agent appropriately redacts any confidential information, otherwise complies with fiduciary duties to the buyer, are there any other reasons, ethical rules regarding why a buyer's agent would be prohibited from producing the agency agreement to the seller?
I'm not familiar with any ethical rules or Real Estate Commission rules that would prohibit it, but a lot of firms have a firm policy in place not to share those. And I think where the questions asked, where this question is coming from, Matt, is often a seller, in particular a builder seller is trying to ascertain how much compensation the buyer is paying the buyer's agent before they're willing to agree to pay compensation. So for example, if I'm a seller and I'm willing to pay 3%, I don't want to pay 3% if the buyer is only paying 2.4%. And I think that's where that question's kind of leading. But again, I'm not sure, Charlie, correct me if I'm mistaken, but I don't think there are any prohibitions provided you have consent from the buyer to disclose it.
I'd agree. There are no prohibitions. I'm not sure that a buyer's agent would want to, but I mean, they can deliver that information without disclosing the entire agency agreement.
Yeah, and it's an interesting cat and mouse game. In my example earlier about the 3% versus 2.4% is a broker who has agreed to be paid 2.4% for representing a buyer by a buyer, and they find a house for the buyer and the seller is willing to pay 3%, the buyer's agent can't take that 0.6 and stick it in their pocket. They have to disclose that fee to the buyer. And the first thing the buyer is going to say is, why don't I get that money? You know, I've only agreed to pay you 0.6. And that's part of the reason why the brokerage community is kind of alarmed by this, is that some of the little tricks of the trade, if you will, like receiving bonuses for bringing a buyer or rebates, things like that, are going the way of the dinosaur. So,
But I will add that Rule 109 has always, or at least for the last 10 years or so, required disclosure of any additional compensation
right.
so that a buyer is not steered toward the spot where the buyer agent is going to get extra money.
Yeah.
Well, Bob and Charlie, I want to thank you both for being with us today, and for everybody attending and for your robust participation. We had a lot of really good questions. If we didn't get to all the questions, I'll see if Sherrod can send a printout of all of the chat messages that came in, and we'll get those to Charlie and to Bob and see if we can get you folks some answers after today. You see here my information on the screen. If you have any follow-up on this program, any ideas for future programs, any additional questions that you didn't get into chat that you'd like to ask, please send those to me and I'll try to get those answered, or to the appropriate person for an answer as quickly as I can. One more time, just reminders for upcoming CLE programs and the annual meeting in Kiowa. That'll be a great time in South Carolina, so I hope to see you all there. And again, thanks to Bob and to Charlie for your time today and for some really great information on this really radical change, what seems to be a radical change between how realtors and the parties conduct their business. So we appreciate you being here with us today.
Thanks for having us, Matt. I appreciate it.
My pleasure.
Absolutely. Okay. All right. Well, bye everybody, and we'll see you next time.